Welcome to the NYU Forum sponsored by Latham and Watkins. I'm Melissa Murray. I'm the Frederick I. and Grace Stokes Professor of Law here at NYU. And in my spare time, I'm also a co-host of Strict Scrutiny, a podcast about the Supreme Court and the legal culture that surrounds it. Accordingly, I am incredibly excited to be here today to moderate this annual preview of the Supreme Court's upcoming October term 2021. And to help me break it down today, I'm joined by a star-studded panel. Joan Biskupic is a full-time CNN legal analyst, but before joining CNN in 2017, she was the editor-in-charge for legal affairs at Reuters, and previously the Supreme Court correspondent for the Washington Post and for USA Today. In 2015, she was a finalist for the Pulitzer Prize in Explanatory Journalism. And in addition to all of this, she's the author of 4 books about the Supreme Court and its members. Most recently, The Chief, The Life and Turbulent Times of Chief Justice John Roberts. Also with us is Roman Martinez, who is the Deputy Office Managing Partner for the Washington, D.C. office of Latham and Watkins, where he's also a member of the firm's Supreme Court and appellate practice. He's argued 9 cases at the Supreme Court and has filed more than 75 briefs before the court. Before joining Latham, Mr. Martinez served as a law clerk to Chief Justice John Roberts and to then Judge Brett Kavanaugh, then of the DC Circuit. And then our final panelist, last but not least, is no stranger to NYU law. Troy McKenzie is a professor of law here at the law school, where he teaches civil procedure, bankruptcy, and a very, very popular seminar on the Supreme Court. He is a graduate of NYU law, and upon graduation, clerked for Pierre Laval of the Second Circuit, and then Justice John Paul Stevens of the Supreme Court. So we are so excited to have all of you. Let's get started and get right into the term that just passed. So let's reflect a little bit on October term 2020. I want to provide a few statistics to situate the audience and the panelists. These statistics come from SCOTUS blog, which has compiled a data set of 67 decisions from October term 2020. These include 57 decisions in argued cases, 8 summary reversals, which are unsigned decisions reversing without oral argument, and then 2 unsigned decisions granting emergency relief from the shadow docket. So 67 cases. Of these 67, 43 of the cases were decided unanimously, slightly below the court's average of 47% unanimous decisions over the past decade. 15% of these cases were polarized along ideological lines, which SCOTUS blog defines as every Republican appointed justice voting in the majority and every Democratic appointed justice voting in dissent. Justice Brett Kavanaugh was in the majority in 97% of the court's decisions and 95% of its non-unanimous decisions, the highest record of any justice. Justice Sonia Sotomayor was in the majority in 69% of the court's decisions and in 45% of its non-unanimous decisions, the lowest of any justice on the court. And Justices Thomas and Sotomayor wrote the most total opinions, a record driven largely by their high numbers of concurring opinions and dissents. Given that empirical portrait, what are we to make of this court? Was this a moderate consensus-driven court, as some pundits have argued, given the results of last term? Or is there something going on that we need to be more attuned to? So this is a question for all of the panelists. Joan, I'll start with you.
Thank you, Melissa, and thanks to my co-panelists and to all of you watching. I think statistics only go so far because all cases are not created equal here. There are ones that have a much greater impact on American life, ones that really change the course of the Supreme Court and show us that they're moving in a new direction. I think that the moderation that you're referring to, Melissa, that might have been some people's assessment before the very last day of the term or last week of the term. And I think, you can't really take a snapshot of the court incrementally. You can't even take a picture of the court just at the end of the term, because the term continues, as everyone on this call knows, until the next first Monday in October. So there's so many other developments. And here's how I would assess this court more broadly. I wouldn't turn to the statistics just purely. I would look more at the more important cases that broke 6-3, that show that we're probably on the edge of a real sea change in American law. I would point out two of the bigger cases that were decided on the very last day. That's the Arizona election case, where the justices, 6-3 conservative liberal majority, chose to narrow the interpretation of Section 2 of the 1965 Voting Rights Act. And also, again, by 6-3 in the Americans for Prosperity case, that's a group started by the Koch brothers, narrowed kind of requirements for disclosure of contributions that could bleed over into the political campaign sphere, which is why that case was watched so closely. And the other one I would pair with those two is another 6-3 ruling that keeps union, coming from California, kept union organizers from temporary access to farm workers on agriculture property, all of which we can do more on if we want to look seriously back. But I just want to say that those kinds of decisions I felt were more revealing than just the pure hard numbers. I also think that because of the relationships on this court and how things have shifted more to the right, it's worthwhile looking at where the center, such as it is. And I'll just close with this comment. When you talked about Justice Kavanaugh being in the majority more than anyone else, in the prior term, it was Chief Justice John Roberts. And just that statistic, again, limited, I would say statistics can only be viewed in a limited way here, does show the rightward shift here, because Justice Kavanaugh is, if you look at his whole body of work compared to the chiefs, he's more to the right.
Right. So, Roman, Joan has offered up a little more nuance to pad out these statistics. Do you agree with this assessment that there's more here than what these numbers suggest?
Yeah, look, I think Joan's right that you got to take the numbers in context and look at individual cases. I think the cases, the three that she pointed to in particular, are important cases to be sure. But I also think if you sort of flash backwards to the beginning of last term and you sort of tried to make a list of what were the really big picture issues that were on the agenda, I think one of the ways to look at that is what are the main issues that were on the table when Justice Barrett was up for her confirmation hearings right around this time last year. And it seems to me that the cases that got the most attention, and this is not just from the left that was concerned about Justice Barrett's appointment, but also from President Trump, who appointed her, it seemed like the two biggest things on the court's agenda last year were going to be the Affordable Care Act case. Number one, this was the third and sort of latest challenge to the Obamacare statute. And number two, there was a sense that was growing that that there was going to be a litigation relating to the 2020 presidential election that could well end up in front of the court. And you saw President Trump, from his perspective, sort of making clear that he thought these were really important issues when he was choosing Justice Barrett. And you saw the opponents to Justice Barrett sort of making clear these were what they thought as the top tier issues. And I think if you look at those as really being the most important sort of areas or cases or potential cases in front of the court last term, I think the sense that you take away is a little bit different from the one Joan laid out with her focus on the 6-3 cases. In the Obamacare case, of course, you had a cross ideological supermajority 7-2 voting to reject the challenge to the Affordable Care Act statute. And then in the election cases, you had, the court completely unwilling to take up any of the meritless challenges that were put forward that by either the president or some of his supporters trying to get the court to intervene in the counting of the ballots and all that stuff that happened after November. So I actually think the headline of the court, I'm not sure I would use the terms moderate or consensus oriented, because I don't think that quite accurately describes it. But I do think that there is I think it's a mistake to focus just on the 6-3 decisions where the justices are more polarized. And I think it's important to reflect on the fact that there really was a wide degree of agreement on some of the cases that were flagged ahead of time as being the ones that were going to be the ideological flashpoints.
So Troy, I'm going to kick it to you. Is Roman correct that the court achieved a rare amount of agreement in choosing to be unsatisfying to either the right or the left?
So I think that's broadly correct. I think if there are two opinions that everyone should read to get a sense of the mood or tension within the court and the sort of potential debate the court is having internally. These are a little bit out of left field, but one of them is Justice Barrett's concurring opinion in Fulton against City of Philadelphia, which was an important free exercise case that ended up not doing what I thought the court was going to do, which was just outright overrule Employment Division against Smith and come up with a new test for free exercise challenges. And Justice Barrett pretty forthrightly says, lots of us don't really like Smith, but we're not sure what's going to replace it. So maybe we should be a little careful in how we proceed case by case. The other opinion is Justice Gorsuch's opinion concurring in the judgment in the Ford Motor personal jurisdiction case, this case I just taught recently. And it is an opinion in which Justice Gorsuch says, I think we should just kind of attach dynamite to the whole thing and blow it up because it doesn't work. We've all been unsatisfied with it. We can obviously do better, and let's think about it. And those, to me, are the two impulses. It's not so much, sort of ideological strain as opposed to mood about the direction and way in which the court should handle change. So my view is the serious change is coming, and the question in the court is exactly how to manage and channel the change that I think a clear majority of the court looks forward to.
So we have the tension between a Tesla and a Dodge Dart in getting there.
There we go. Melissa, can I just jump in on that point?
Sure, of
Because
course.
I thought that analysis was exactly right, and this ties into a point I think Joan was making earlier. I think one way to think about the court is along the sort of like, is it a Republican appointed justice or Democrat appointed justice? But I think the more nuanced way is really to look at maybe, to paint with a slightly more nuanced brush, but maybe not totally nuanced, is, maybe there are three camps on the court. And you sort of have not just, the Republican appointed bloc is not really all aligned. They may be aligned, bottom line on substance on a lot of things, but I think they are not aligned in the way that Professor McKenzie was talking about in terms of sort of temperamentally, like how far to go, how fast, how careful to be about things like precedent. There are a lot of prudential type judgments that justices make that don't turn on whether they think the law means X or Y, but rather turns on like, should we take this case for review now? How broadly or narrowly do we need to rule? And I think that the limited track record we have so far suggests that maybe the Chief Justice and Justices Kavanaugh and Barrett are a little bit more sort of temperamentally or prudentially moderate in that sense, not necessarily where they would ultimately come out if they had to, write down their views on every last issue, but they seem to be in a kind of go slower mode. I guess that makes them, what are they, the Dodge Dart then in your analogy?
They are the Dodge Dart.
I don't know if they'd like that comparison compared to the snazzy Tesla, but I do think that sort of nuance and sort of the divisions within the Republican appointed justices are enlightening and are important to focus on.
Well,
Melissa, can I add one other thing here?
Sure, go ahead, Joan.
And this just goes to a broader point that I think all of us on this call are aware of, but I just want to bring it home to the audience. And that's one of expectations. Rahman is right that at the last fall, everyone was talking about the Affordable Care Act case as if it was really hanging in the balance. And frankly, none of us on this call probably thought it was, because we knew the reality. We knew what a far-fetched claim that was. Plenty of conservative scholars were against it. It was kind of crazy that it had made it as far as it did. But yet it was a major talking point that soon to be Justice Barrett was going to somehow take it down, and it would be the end of Obamacare finally after the third challenge. And I think that sort of rhetoric certainly has its place. And I understood why so many people were saying that, but I did think that also set up a false expectation of what was to come. And then I also think, going to the point of all as I said earlier, all cases are not created equally. All the conservatives aren't created equally. All six now have their own mini blocks within them. And I thought Troy's use of the Ford Motor Company case was perfect, because Justice Gorsuch does not have the same regard for consequences and what's going to happen with a ruling as Justices Barrett or Kavanaugh do, and that's going to shade how they rule. So these are all things that we all hopefully bring to either the story or to academic teaching or practicing, but they do tend to get shorthanded. And I think going into this new term with abortion definitely hanging in the balance, it would be good to offer certain caveats when we get to that and the gun case.
I think it's an excellent point that all of you have made. It may also be the case too that what unites the three in the middle and the three on the right is that the three on the right have been, or at least two of the three on the right have been on the court for a long time now, over 15 years for Justice Alito and now 30 years for Justice Thomas, whereas Barrett and Kavanaugh are relatively new to the court and have a longer history ahead of them, more room to run their dodge darts, as it were. So maybe they aren't quite as exercised about time.
They could trade up. Maybe that's the right way to think about it.
We can only hope to get an upgrade in the Hertz premium line. A separate set of statistics for all of you. Harder, I think, to nuance these statistics, but Bloomberg's Kimberly Robinson reported that of the 106 lawyers who argued before the court in the last term, of that 106, 79% were men, 21% were women. And indeed, just 5 men argued 13% of the cases before the court this term. And all of them were veteran SCOTUS litigators like Paul Clement, who has argued over 100 cases before the court. One of these advocates in that 13% was Paul Weiss's Canon Shanmugam, who's a person of color, but notably, like women, people of color are also very underrepresented at the lectern before the court. So what explains this empirical portrait and what might be done both at the court and in the larger ecosystem that surrounds the court to move these numbers in a more positive direction for women and people of color? And Roman, I'll start with you.
Sure. Yeah, no, I think, look, I think that the most straightforward explanation is that you have a number of experienced advocates who, like Paul Clement, who is just universally recognized to be really one of the greats in arguing cases in front of the Supreme Court. And if you are a private company with a case in front of the Supreme Court, your board of directors and your CEO is never going to second guess you if you hire Paul, because he's terrific. And so I think that there's a, there's a certain self-reinforcing quality to this, where if you have folks who are there and they get there often enough and they do a good enough job, they're going to continue to get assignments. And I don't think that's a problem in the sense that, I don't think it's this is something that's Paul's fault because everyone wants to hire him. I think my own solution to this problem, of course, as a Hispanic American Supreme Court advocate, is that the Supreme Court should grant all my cert petitions and all the clients out there should hire me to represent them. I think more realistically, there's probably no short-term answer. I think one thing that is a positive development on the diversity front is Elizabeth Freelager becoming Solicitor General. She will single-handedly up the number of arguments being done by women quite substantially, especially in the big cases, because once she's confirmed, as she should be, she will be arguing probably one case a month, and it'll be the big cases. I think that, over the long run, people who come out of the Solicitor General's office as a former Solicitor General get a lot of tailwind behind them when they're setting up a Supreme Court practice. There are other folks who have done it not at the SG level, but at the sub-SG level, who are doing great, like Lisa Blatt and others. But I think that will be a help. I think in the long run, there is still a pipeline problem. We need to get great, talented candidates, make sure that they're getting hired as law clerks at the court into great law firms that do these kinds of practices, and getting hired into the SG's office. And I think there is progress in that direction, but it's not overnight, unfortunately.
Troy, is this a funnel and where we have lots of people getting in at the pipeline at the top and then it sort of winnows down, or does it work in the other way? And this is more like an inverted funnel where the opening to get in is quite narrow.
So I think there are two solutions along the lines of what Roman just said, or the court could triple its docket and take a lot more cases. I mean, some of this is a result of scarcity. The fact that the court grants so few cases as a percentage of its overall, the overall number of petitions filed, puts exactly the kind of pressure that was just mentioned on those parties who are looking to get cert granted. And it means sort of the rich get richer. If you are someone who already has experience arguing before the court, you are far more likely to get clients come to you and seek your help in filing a cert petition, because the stakes are so much higher, since the court just doesn't grant that many cases. I mean, the number of cases the court's granting, I mean, just to give the audience a sense, circa 1985, 1986, just before Chief Justice Rehnquist became the chief, the court was hearing somewhere between 140 and 160 cases a term. I mean, it would sort of bounce around, but it was literally double, maybe even now a little bit more than double where the docket is right now. The other thing I would say is, of all of the pipelines, the one that to me is the most important is the Solicitor General's office, because if you just look at the careers of those who dominate the current Supreme Court bar, including the leading women who are arguing before the court regularly, the common thread is that they have experience as assistants arguing cases before the court in the Solicitor General's office. And actually, I lied. One more thing I would also add. This is a feature throughout the entire elite bar, to be honest with you. This is true for trial lawyering as well. The number of lawyers who are actively litigating major civil cases, for example, through trial, in some ways is shrinking. And you find relatively senior lawyers who tend to be less diverse, handling even more cases than they handled 15 or 20 years ago, because of the same dynamic of clients wanting to go to those who already have piles of experience.
All right, so
Melissa, can I add one observation?
Sure, please do, Joan.
Back in 2014, when I was at Reuters, we studied some 12,000 petitions that had come in, and who was getting their petitions accepted, and then who was able to argue. And the statistics are essentially the same, the kinds of percentages you read from the Bloomberg piece there. But we had done just a lot of data crunching. And as part of that project, I talked to all the justices themselves. And all of them spoke on the record except for the chief. He was helpful in his way, because he's a former advocate himself, argued 39 cases. But the justices, surprisingly, to a person, including all three of the women, said, we like having someone who we're familiar with. We like having someone who maybe they know from, has presented before. Now they may have changed their tune on this, but they were not afraid to say that they reinforce this idea that they want a known quantity. And after we ran that series, and it was a 4-part series, Justices Kagan and Scalia happened to be giving a speech. I think it was down in Louisiana or Texas, I forget, it was somewhere in the 5th. And they were asked about it, and they both said, again, no, we like seeing people who we know, we can trust what they've put in the briefs. We know that they understand what we're asking about. I do think the justices at that time, and maybe they are now, are a little bit sheepish about that stance, because the truth is that the advocate himself or herself isn't supposed to be one of the criteria of why your case is accepted or why you get to argue. It's just that it's baked in, just as Troy and Ramon have mentioned, that success begets more success.
Yeah, and it certainly will likely influence the behavior of those who are hiring advocates, but it also has direct repercussions for situations where the court is in a position to actually select advocates to take on particular positions. So those amicus assignments, which I think my colleague Kate Shaw, who's at Cardozo, has actually done a study where many of those invitations for amicus arguments go to former clerks of the justices themselves. So there is a lot of network effects at work here. But Joan, and let me just say, if you're enjoying the conversation and would like to add to it as well, please drop your questions in the Q&A function. We'd be delighted to take them as we go along or at the end. So please just put them in there. Joan, here's another place where we saw some interesting new gender dynamics, which is to say that the court this term saw a shift in its personnel when Justice Amy Coney Barrett joined the court, replacing Justice Ruth Bader Ginsburg. The Barrett confirmation hearings, I think, had some very interesting gender dynamics, which we can talk about. But I'm also really interested in how the advent of a new justice changes the dynamics among the members of the court. And what did this particular personnel change mean for this court, and more particularly the Chief Justice, who had enjoyed outsized influence as a swing justice, as it were, for the last couple of terms since Justice Kennedy's departure?
That's right. Not only was he at the center ideologically, but he also has this great power of assignment and running the court in an administrative way. So the chief really had terrific control for that period after Justice Kennedy had left until Justice Barrett came on. And the ramifications of the Justice Barrett appointment, given who she succeeded, Ruth Bader Ginsburg, who was arguably, at the very left extreme with Justice Sotomayor, for someone who, is clearly, and will say that she's a conservative, makes such a difference in terms of the cases that they're now taking, the way they're probably going to decide many of these cases. But just in terms of the chief, as you asked, Melissa, it slightly displaced him. I do think we still need more evidence, because in terms of just how he's going to handle this. I did one of the Practicing Law Institute's end of term programs in early August. And my message was, do not count out the chief. The chief is going to, John Roberts is so effective, so persuasive, so winning in so many ways that I still think that John Roberts will figure out a way to control this court and to steady it and to try to not have it lurch too far to the right. Well, after Texas, I don't know if I would say that anymore. In fact, I would definitely not say it. I would just say we need to see more, because I really did feel that was the Texas abortion case, when he said to his colleagues, let's just wait. Let's not have this law take effect. There are all sorts of novel procedural questions here, and maybe there's nothing we can do, but we just don't know yet. And I felt like he of all people did not want the state of Texas gaming the federal judiciary, as it seems to have done here. And I thought, when he could not persuade one more person over to that camp, I thought it was so revealing, especially given that Justices Kavanaugh and Barrett have at least signaled in some ways, either through the Fulton concurrence or other votes of Justice Kavanaugh since he came on in 2018, at least some openness to listening to the chief on those kinds of issues. So I just wonder what this signals going forward on cases, but it certainly, that was one major episode on a momentous topic, abortion, that showed him not having control.
So Ramon, do you agree with that? Has the Chief Justice been outmaneuvered? Is he all alone in that Dodge Dart as Justices Barrett and Kavanaugh hop a ride in a Tesla?
I wouldn't go that far either, but I think that, look, I think it's probably fair to look at those three justices as being in the middle of the court. And I think the chief of the three of them is probably the closest, both on substance and on kind of the prudential questions to the left. So whether it's 3-3-3 or 3-1-2-3 or however you want to do the math, we're all lawyers, so we're not good at math. I do think that the chief is on the left side, and so I think he inevitably is maybe not the decider in the way that he was for the brief period of time when he really was the median fifth justice. I think the one interesting statistic to look at over time is going to be, if you think of those three justices in the middle, like what's the percentage of cases in which if you get a majority of them, you win the case? Last year, the answer was 97%, but that would have been true just of Kavanaugh himself. So I kind of think, though, that is the center of gravity on the court. And I think that Justice Barrett's ascent to the court is most significant, although I think her questions have been great. She's been, by all accounts, a very important contributor to the work of the court. I think that her sort of just shifting that alignment and moving the chief into kind of the slightly left of center position, remarkably enough, is probably the biggest impact of her ascent to the court.
Amy Coney Barrett has made Chief Justice John Roberts a liberal, as it
There you
were.
go.
Troy, any thoughts on this?
I think basically I agree. John Roberts, when I was clerking, was still an advocate at the bar, and he was an extraordinarily effective advocate. One of the reasons he was so extraordinarily effective is that he didn't he sort of had a sense of confidence and candor that he could modulate very well, and he's used a lot of those same intellectual and interpersonal skills as chief. Whether or not in the short term it will actually change the speed at which the court takes cases, or the kind of the way in which they develop the law, I'm not sure. But I would still think that in the medium to longer term, he's savvy and effective at trying to guide the court. And so I guess I'm in the camp of saying don't count him out. Although then again, votes are votes, and the chief has exactly one vote, as each justice does. So it's only opinion assignment and persuasion, and the sort of accretion of trying to show your colleagues, look, I told you in the last case, don't do this because this bad thing would happen. And then if the bad thing happens, you can come back to the colleague and say, see, I told you so. But that takes time. So I think the short answer is we really might not know in this coming term exactly what the chief's ultimate position will be on the court. But in the longer term, we will definitely see if he can exert the same kind of power and influence he has exerted in the last few terms.
Can I make one point, Melissa? Or sorry, do we need to move on?
Well, you can make it briefly.
I'll just make it very briefly. I think there's a trend in some of the writing about the court in recent months of that has tended to view Kavanaugh and the chief as being like sort of soul brothers or something, where they're kind of like with each other, and Kavanaugh is just sort of following the chief along.
I think this is because of an Atlantic profile of Justice Kavanaugh.
Yeah, exactly. That's exactly right. I think it was that profile, and I do think that is just very mistaken. I love both of them. I clerk for both of them, but I think that there are a lot of similarities. But I also think if you look at the cases in which the two have disagreed over the last 3 years, they've disagreed on some very fundamental, foundational cases that are like sort of front page of the New York Times or CNN type cases. And so I think it is a mistake to think of them as being sort of like always in the same place, even though there may be similar in certain respects.
Yeah, I think that's right as well. Joan, you alluded to the Texas SB 8 case, which was decided on the shadow docket. And alongside all of these changes of the court, one of the things that really came to the fore in the public discussion about the court was the emergence of the shadow docket. And to be clear, the shadow docket was not created this year. It has long been part of the court's general docket, but it has become more public this year. So Ramon, can you tell us what is the shadow docket, and can you explain why it has become such a topic of conversation and controversy?
Sure. So just briefly, the shadow docket, I think, generally refers to essentially everything the court does other than its merits decisions in cases that it grants certiorari on, asks for briefing, and holds oral argument on. And so, essentially the shadow docket would encompass things like, the decision to grant certiorari or not grant certiorari. It would also encompass the various stay applications or emergency applications for interlocutory appeals and other things that come to the court in other contexts. Those decisions historically, on the reason it's called the shadow docket is that those types of decisions are sort of stuck in the shadows in a sense, insofar as they don't get the same kind of public attention. There's not as much transparency, either in terms of what the advocates are arguing, because you don't see oral argument, but also in terms of the decision-making process. Often the justices are deciding these shadow docket issues without issuing an opinion or by issuing only very short opinions. And I think it's become increasingly controversial, or at least has become more of a topic of discussion, because there do seem to be a lot of issues that are making it onto the shadow docket and are leading to decisions that end up having real world effects on a large number of people. In the Trump administration, you had the administration going to the Supreme Court. I think they would say, not without justification, they were going more frequently, in part because you had a lot of district court judges that were issuing nationwide injunctions at a much greater rate. So they felt, the SG's office felt the need to kind of go to the Supreme Court to, to stay those injunctions and allow policies to go into effect. In the last couple of years, though, you also have people ideologically on the other side who are trying to use the shadow docket to get relief. For example, the parties in the Texas case that we were just talking about, or also you have a lot of federal defendants on death row who are trying to get stays of execution and whatnot. And so I think that there is a legitimate sort of debate about the lack of transparency or ways to enhance the transparency. I am a little bit sympathetic to the justices, though, which is insofar as the shadow docket is kind of there and it's in the shadows for a reason, which is that these tend to be sort of shorter notice issues that come to the court that don't lend themselves to a long drawn out briefing schedule. And the court's got to decide these issues more quickly and make snap judgments. I don't know that there's any easy way to get around that. But there are certainly ways that the court could maybe bring that docket out of the shadows, at least in some cases, either by holding argument in some instances, or maybe by issuing longer or more considered opinions. That's it in a nutshell, as far as I understand the debate.
Melissa, could I just say very, very, very briefly, I want to.
I actually have a question for you. So.
Oh, yes. Okay. Yeah.
I'm cold calling on you. So one of their audience members would actually like to know about the implications of the growing use of the shadow dockets, which I thought you would be right up your alley. So what are the consequences of the court using this as a means of resolving issues, given the concerns about transparency, the concerns about the lack of time, oral argument and briefing and whatnot, and the difference between the shadow docket and the traditional merits docket?
So as you said, the shadow docket is not something that's new. The court has a fair amount of discretion over what cases it takes, and has always had a kind of emergency application docket to deal with things like capital cases, stays of execution, other types of requests for relief, sometimes just interim relief, but requests for relief when there's something bubbling up below in the lower courts. The term itself, though, was popularized by a piece written by Professor Will Baud at a symposium here at NYU, going back, I think, maybe about 7 or 8 years ago. It's a piece that he eventually published in the Journal of Law and Liberty here. And I actually think if you go back and read that piece, he put the shadow docket cases into 2 broad categories. And I think they kind of capture the concerns. One, he said, were cases in which the court was enforcing its supremacy. So there's a recalcitrant lower court. The law is really clear, and the court is just intervening to say, we kind of said this 3 or 4 times. We don't need to have full briefing and argument. And the other he called sort of lightning bolt cases. And the problem, or the one problem with the recent rise of more cases on the shadow docket, is that the categories seem to be scrambled now, where the court is acting in a manner as though it is enforcing its supremacy within the hierarchy of the court system. You could say that there are novel and difficult questions that are being handled as though they have already been resolved without the full briefing and argument. The ad hoc side, the error correction, random types of things that are happening, I'm not sure that's as different. It's really the expansion of that first category, that confusion about the first category that I think makes a difference. Having said all of that, I don't see a future in which the court ever gets rid of what we call the shadow docket. The real question is when they decide to take more items onto that docket and make significant moves that appear to be changes or broadening of the law without going through their normal process of briefing and argument.
And Joan, the court has a fair degree of autonomy in terms of how it handles the shadow docket. So just in the last couple of weeks, we saw it move a case, Ramirez versus Collier, from the shadow docket to its regular merits docket. We also know that in SB 8, that was a shadow docket request, but there was also pending on the merits docket an actual abortion case that would have repercussions or ramifications for at least some of the substantive questions presented in that Texas challenge. So why does the court decide some of these quite pitch decisions like SB 8 on the shadow docket when it could just sort of put things on ice for a little bit until some of these other issues are resolved on the merits docket?
Well, they can basically do whatever they want. That's the baseline, first of all. They write their own rules. They can bend their rules when they want to. For example, moving a case that's come up in an emergency basis to the merits docket. But mostly, the way these cases are coming to them, just at first blush, is because there's some sort of emergency situation that the premise is that maybe there wouldn't be time to actually hold a full merits briefing. For example, an execution, or in this case, the Texas law was about to go into effect. So they really needed to act. It's just that the way that they acted felt so unsatisfactory to people, because they did essentially just say, we can't do anything here, even though something very dramatic and unconstitutional is about to take effect. But they have that discretion. And the other thing they have discretion on that I think we're seeing a little bit more of is what they write. You think back to 2019 when they were handling a lot of the Trump-related policy questions that would come up on the in this manner on an emergency order on the shadow docket. They wouldn't say anything. They would, for example, when they let the Trump administration redistribute funds for the wall at the southern border, it was a 5-4 decision with no writing on the part of the majority. I think they've gotten a little bit self-conscious about the fact that they're not explaining why they're allowing this. So I know that, one paragraph of explanation on why they allowed SB 8 to take effect certainly fell short in many people's minds. At least they did say something that time. And at least there were dissenters, because as you know, just a couple of weeks earlier, when they handled the US asylum policy, neither side wrote in that one. When they handled the eviction moratorium one, at least there were some dissenters. So I think what people want are some reasons. And this is the other thing, the justices themselves are always talking about how they explain themselves. Well, the shadow docket area is one place where they just haven't explained themselves. And do you want me to segue quickly into the Mississippi abortion case, or would you rather wait?
Well, I think that's a great time. It's a great time to sort of turn to the upcoming term. So we know that the court certainly at least has the upcoming barn burner of a term in mind. And we've seen 3 justices hit the speech circuit to disclaim the view that the court is nothing more than a group of partisan hacks. This is obviously shaped by what's coming down the pike. And so we have this really fraught term where a number of controversial cases will be argued. And obviously top of mind for a lot of people is the case Dobbs versus Jackson Women's Health Organization, which is a challenge to Mississippi's HB 1510, which prohibits abortion at 15 weeks. So Joan, what do you expect to see in that case, and how is it going to interact with the growing challenges to Texas SB 8, which are happening on the ground in that state?
I think the Texas SB 8 case has just rattled everything. I went back and I looked at what I had written at the time that the Mississippi case was pending. And that one, just so our audience knows, that's a 15-week ban. Mississippi has a law, it hasn't been enforced, but it says that that once you're 15 weeks along in the pregnancy, you cannot get an abortion. The Texas case is just 6 weeks of pregnancy, when many women wouldn't even be aware that they're pregnant yet. So there's the Mississippi one, the petition had been pending for, I think, 6 or 7 months before they took it, for a very long time. You could tell that the justices were torn on whether to do it. Justices Gorsuch and Thomas had been saying, we have to go back into this area because it's such a mess. Justice Thomas has wanted to reverse Roe. So you had that kind of pressure, but then obviously you have the pressure from the left not wanting to do anything. And then Chief Justice John Roberts, who's making these incremental moves, as we saw in the Louisiana June medical case just last term, changing the standard of how the court might assess abortion litigation, but not calling for any kind of reversal. So I think that when we first knew that they were going to take the Mississippi case and it was going to be argued sometime this fall, just so people know, it's now been scheduled for December 1st. We thought, let's see what they do to that kind of a ban. But the Texas one has seemed so dramatic in comparison that I think frankly, it has changed my prediction. I just feel that they seem more readier to do something faster. And one last point I'll make is that the legal issue turns on The viability question. In Roe versus Wade in 1973 and Planned Parenthood versus Casey in 1992, the Supreme Court set as sort of a cutoff for government regulation when a fetus would be able to live outside the womb, viability. And both of these laws challenge that because it's not until like 23, 24 weeks that a fetus would be viable. And to move it backwards to 15 weeks, first of all, is before viability, and 6 weeks is way before viability. That completely challenges the fundamental principles of Roe v. Wade and Planned Parenthood.
So Roman, Troy, do you want to weigh in on this? Have you changed your mind based on what you've seen the court do in SB 8 about how they might handle the Dobbs case?
I have to say, I have no clue, actually. I stopped making any predictions about abortion cases at the Supreme Court. But I do think that the Texas case, because of the oddball procedural framework, the way in which the statute was sort of drafted in order to take advantage of the potential differences between standing in state court as opposed to standing in federal court. My sort of like surface take was, although it was surprising that the court did not consider it appropriate to give more explanation about what it was doing and why it was not intervening at an interim stage. It didn't strike me as completely off the wall because of that weird procedural packaging. So I'm not sure how much of a signal that gives about what's going to happen in the Mississippi case. Maybe the bottom line will be the same, but I'm not sure if the reasoning will necessarily be as far reaching. Because what you might say, look, the fact that the court let the Texas statute go into effect means that the Mississippi statute, which is in some ways more limited than the Texas statute in terms of its reach, well, obviously that's okay too. But I'm not sure you can actually draw that conclusion based on the oddball procedural wrapping in which the Texas case came to the court.
Roman, can I ask a question about maybe your former boss, the Chief Justice? This case will be argued on December 1st. It likely won't be decided until May or June of 2022, which is only a few months before Americans go to the polls to vote in the midterm elections. And both chambers of Congress will likely be up for grabs in that midterm elections. Do you think it's likely that that's something, those institutional dynamics would shape the Chief Justice's own views of how to deal with this challenge in Mississippi?
I don't think so. Joan has studied that. I know the chief from working for him and sort of being in touch with him ever since I became an alum of his. Joan has literally written the book on the chief. But I'll just say there's nothing in my experience with him that suggests to me that he's ever sort of got his eye on like the electoral timetable or anything like that. I mean, I think there's, their background understandings that abortion is a very controversial subject, and that, people who don't like a ruling one way or the other are going to be very upset about it and are going to, direct a lot of that anger or upset at the court. But I don't think he's like sort of consulting the political timetable in that way.
One thing I will note, as someone who studies this and spends a lot of time thinking about it, and this goes back to Troy's point, the thing that I think is so interesting, and like you, Joan, I think my own views of what the court might do in Dobbs have been completely disrupted by what's happened with Texas SB 8. But I think one of the things that SB 8 does has sort of shifted the Overton window such that a 15-week ban, which I think 2 months ago would have seemed quite extreme, now actually seems more reasonable and moderate than it did just a few weeks ago, given how draconian the Texas scheme is. So again, lots of activity with abortion, and I think that will probably be the most watched case. Well, there are others, but I think that might be one of the most watched cases of the term. But Roman, you have another case that you have your eye on, and that involves the very vexed question of gun rights. I'm no less vexed than abortion. So can you tell us a little bit about NYSERPA versus Bruen, which is another take on the whole question of what the scope and substance of the Second Amendment is?
Yeah, so of course the court recognized an individual right to bear arms for self-defense, at least in the home, in the Heller case, and then it incorporated, it held that that right was incorporated against the states in the McDonald case. Both of those about, I don't know, 10, 11, 12 years ago. But since then, the court hasn't weighed in on the Second Amendment right. And so there have been a lot of cases that have been brought in a lot of other contexts, challenging a lot of other laws and trying to really figure out exactly what those two decisions and especially what mean, and especially what Heller means. Because Heller, although it recognized an individual right, it also had some very strong language in there, essentially opening the door to at least certain longstanding types of gun regulations. And it gave a number of examples in the opinion. I think courts have really struggled with figuring out exactly, how to reason from Heller to figure out how to apply Heller's rules to subsequent cases. So the court has now taken the New York State Rifle and Pistol Association case, which involves a statute in New York that requires people to have a special license to carry a handgun for self-defense outside the home. And so New York basically has different types of licenses that they give you, other than just your right to have a gun at home. If you want to carry a gun in public on your person, New York essentially requires a special justification going above and beyond like the normal citizen. They need you to give a good reason, and they vest discretion in New York state officials to figure out whether you are unique enough to in your needs for self-defense to justify getting a license. And I think what the case is going to do is give the court the opportunity to weigh in on kind of two issues. The sort of meta issue is what's the legal test for analyzing Second Amendment claims? Most of the lower courts have applied a version of strict or intermediate scrutiny, but basically sort of the way that a lot of other constitutional rights work, you kind of balance the right versus how good a reason does the government have, what alternatives does the government have to attain its objectives, and you sort of do a little bit of a kind of balancing test. But Justice Kavanaugh and Justice Barrett have issued opinions when they were on the lower court, sort of saying that might not be the best way to look at it, and rather you should look to history, text history, and tradition, and figure out whether the regulation in question is something that historically would have been okay, regardless of what we think about the government's policy objectives. And then if historically this kind of thing would have been okay, then it's okay. If not, then it's unconstitutional. And then the second question, other than the sort of standard of review question, is really about what is the particular text, history, and tradition bearing on whether you have a Second Amendment right or an individual right to bear guns outside the home. And here, I think one of the interesting things about the case is, as someone who's very interested in sort of originalism, I think this case is extraordinarily well briefed on both sides. And I think there's a lot of historical evidence that is on both sides of this question. And so I think, if you really put your originalist hat on and you kind of delve deeply, the case sort of seems to turn on how you interpret some of these older statutes that did seem to basically forbid people from taking weapons out in public. There's a debate, though, about whether those limitations historically were limited to kind of brandishing those weapons to terrorize the public, or were they just general prohibitions on carrying in public spaces? I think there's a really interesting historical debate about that gets a lot of play in the briefing. And so the justices will have the chance to say a lot about what the Second Amendment means in this case.
Troy, Joan, anything to add to Bruen?
Just two brief thoughts. One is it is interesting to look back at Heller, which was somewhat circumscribed in that Justice Scalia made it clear, perhaps in order to get a majority, that the holding went no further than the possession of a gun in the home for defense of the home. That was really what the court made clear it was deciding, and no more. Obviously, the next question was, well, what about outside the home? And so this case really does set up what is the natural next question after Heller. But Heller was 13 years ago. It's not like Heller was decided yesterday. So in some ways, I'm somewhat surprised the court has taken this long to come back to this question. The other thing I'll note is that one case for originalism is that it gets the court out of the business of being philosopher kings, trying to figure out what the ideal society is like, what is the good life, and instead there's a kind of a foundational set of materials that any good lawyer can look to and through a process can come to a conclusion on. And as Ramon says, there's a lot of historical material on both sides here. The justices are not trained historians, and yet in an originalist framework, they're being asked to be professional historians. Well, they're not professional philosophers. Why do you think they're professional historians who can make that type of decision? But I think that is the way the modern court thinks about these types of cases. So advocates have to brief the cases that way.
You know, I'll just add why now? Because I know why. They've had other opportunities, but they didn't think they had the votes. And it's with the addition of Amy Coney Barrett succeeding Justice Ginsburg that those who want to extend Heller felt like they could take a case. You probably remember actually 2 years ago now, when the justices had another New York State gun restriction before them, and it looked like that was all teed up, and they went off on mootness, and there was just a lot of unhappiness on the part of Justices Thomas, Alito, Gorsuch, and they had before them then more cases that they could have taken. But at that point, it was, the chief was not ready to do anything dramatic in this area, and they didn't think they had the 5 votes. But once Justice Ginsburg passed away and Amy Coney Barrett came on, I think that changed everything. And it'll be interesting. Ramon probably, I know, knows this record much better than me, but do you think there's an off ramp in terms of the record below? Is there any way they can punt on this one the way they did on the earlier New York one?
I don't see anything. I mean, I think that New York one was a kind of unique situation where New York, saw the tea leaves and repealed its statute, some would say in order to manipulate the court's jurisdiction and prevent it from ruling. And it worked. You had Chief Justice Roberts and Justice Kavanaugh thought the case was moot as a result of that, and agreed. But I don't think there's an off ramp. I mean, I think Justice Kavanaugh, even when voting to dismiss that case, basically said there's some really big important issues that need to be resolved in this area, so keep the petitions coming. He didn't quite say it in those terms, but he signaled that he was open to granting a case. And so I don't see anything in the record that would suggest an off ramp.
Okay.
And Joan, I believe it was in June 2020 that the court denied cert, I think about 10 petitions involving the Second Amendment.
Yeah, actually, that was just a little over a year ago. I'm getting my terms mixed up. Yeah, and that's exactly when the case, the earlier case, the New York rifle case, first came up. So a lot has happened in those intervening months, but you're exactly right. It was just in June of 2021.
2020. So a real shift in the court's personnel has, I think, opened the door on some of these issues. Troy, one area where the court has taken a lot of cases and actually done quite a bit in terms of jurisprudence is in the First Amendment. And this term, the court is poised to take up yet another First Amendment case, this one involving a challenge about public funding to religious schools. And it picks up where an earlier case, Espinosa versus Montana Department of Revenue, left off. So can you tell us a little bit about this case and the landscape for public school funding that comes out of it?
So this case is it's an interesting case. In some ways, you could say that it might not have a broad reach, depending on what the court says, or might have a very broad reach. Very briefly, so that the case is Carson against Macon, and it comes out of the First Circuit, U.S. Court of Appeals for the First Circuit. It involves the way in which Maine funds its public education system. Because Maine has large areas that are rural and in which the school districts basically do not have a public school, Maine, in effect, will pay for students to attend private schools. And the way Maine frames this program is the private schools are sort of stepping into the shoes of the state to the extent that there are no government erected and funded schools in the local area. But there is an exclusion. If the state determines that a school is sectarian in nature, then a parent cannot get the same support upon sending the student to that school. The case that teed up this case as the kind of the next big First Amendment case in the area is a case from I guess it was probably about 2 or 3 years ago now. It was from, 2020, which is Espinoza against Montana Department of Revenue. And in Espinoza, the Montana courts had said that because the state of Montana had I think it was a state constitutional restriction on any aid to a school that is controlled in whole or in part by any church, sect, or denomination, the state's tax credit system that was meant to allow parents to send their kids to various schools could not be applied to religious schools under the circumstances. In that case, the court ended up saying that the Montana state constitutional provision under the circumstances violated the free exercise clause, but it did not, it framed the question as whether or not you looked at the institution overall as opposed to the use to which the money would be put within that institution. So Maine relies on that distinction by saying we're not discriminating against religious schools. We simply take a look to see whether that school in its day-to-day teaching is the equivalent of a non-sectarian public school education, or whether it is, we don't want to fund actual religious instruction. That's what we don't want to do. I'm not sure what the court's going to do with this case in light of the trend Espinoza. There's another case called Trinity several years ago, as well as the Fulton case that I mentioned at the start of the program. I suspect that the court will probably, this program is one that is going to run into a potential buzzsaw at the court. I'll put it that way. At the same time, Maine can say we're unique. We're not trying to target schools because they are run by a religious organization. We're simply trying to find a school that can step into the shoes of the government, and we are legitimately concerned about funding religious education. I'll end on the one point though, just about the doctrinal cubbyholes into which this case fits. The plaintiffs here are challenging the Maine restriction under the free exercise clause, but they also have an equal protection challenge as well as an establishment clause challenge on the ground that there's really hostility to religion and religious institutions behind the Maine program, and that's the equivalent of Maine establishing non-religion as almost a form of religion. So it's an interesting and creative set of arguments that the plaintiffs have put on the table.
Thank you. All right, so that's a big case that will likely have some repercussions for the whole debate over school vouchers. Another area that will shade into questions about education policy is a case that hasn't actually made it to the court's merits docket, but is still pending on its cert docket. And that, of course, Joan, is Harvard versus Students for Fair Admissions, or FAIR. So can you tell us a little bit about this case, which is a challenge to affirmative action policies in higher education?
Yes, this case was brought by an advocate by the name of Edward Bloom, who's based in both Texas and Maine, who has always fought against government policies that are based on race. He was the advocate behind the successful Shelby County versus Holder case that involved the Voting Rights Act. He's challenged redistricting plans. And he was also the mastermind behind the Abigail Fisher versus University of Texas at Austin case. And in this one, what he's done is he has gotten together a group of people to challenge Harvard's admissions, specifically as they relate to Asian American applicants. And he said that Harvard, in its screening, favoring minorities who've been traditionally disadvantaged, Hispanics, African Americans, Native Americans, that in favoring those people, giving them a bit of a plus factor in their applications, it has hurt high achieving Asian Americans. So it's been a pretty attention-getting case. And I covered the trial up in Boston because I've just been so fascinated by the advocacy of Edward Bloom and how far it keeps getting. And he lost at the district court level. Harvard prevailed, and Harvard prevailed also at the First Circuit. But here he is before the Supreme Court, thinking that given the kinds of signals we've had from the conservatives and from the Chief Justice, who really doesn't like what he's referred to as this divvying us up on the basis of race, that he will have a more favorable audience. And again, it's brought under Title VI of the 1964 Civil Rights Act. It's not at this point a constitutional equal protection claim, but they're Title VI and the Equal Protection Clause, essentially provide the same coverage here. So it would, whatever would happen in this Harvard case would obviously also affect state schools and other private schools. There's a similar case coming up from the University of North Carolina, where Edward Bloom's team has challenged that state schools policy, again, with an emphasis on Asian American applicants who might be squeezed out. They built a very intense record. The trial in Boston went for several weeks. And then Judge Burroughs, Allison Burroughs, who was a newly named judge at that time, she's going to be, I'm sure, a veteran by the time this case is decided. But just so our audience knows, the petition is up there, but the justices requested the views of the Biden administration, which are bound to be the opposite of the Trump administration, which was siding with the challengers, saying Harvard should not be able to do any kind of race-conscious admissions.
So Joan, given that it's likely everyone in the court knows where the Biden administration's stance on this will be, why did they request the Biden administration's views on this?
Well, I think the they there, I think, was the pressure from liberal members of the court who thought, it may be inevitable, but why not delay it? Why not just buy a little more time? And again, going to the idea of what they've already got on their table for this new session, why add one more thing, which could potentially be reversal of Bakke and reversal of Grutter? So the two cases that allow higher education institutions to use race in admissions decisions. So I think it essentially put off to potentially next session. Now, the Biden administration, I would presume, and I have no inside intelligence here, and Ramon, who used to work in the SG's office, might shed light on this. I would think the SG's office might want to file its response at least by the end of the year. So it didn't look like it was trying to especially delay things. And I think December is a cutoff, but I don't know. What do you think? Do you know, Ramon?
Yeah, look, I think the normal policy when you get a CVSG at a call for the views of the Solicitor General order from the court at the time when they got it would be that they would file the brief in time for the court to be for the case to be considered for this term. So that would mean probably filing, I can't remember exactly what it is, but it's probably like November. And then, the parties would have 30 days to respond, and then the case would then go to conference, sometime in early January, probably. That said, I do think that if the court, if enough members of the court wanted to kind of kick the can down the road a little bit, I think they could kind of push it so that even if they granted cert in January or February, they could push it to be argued not this term, but next term if they wanted to.
So this may be a pace yourself strategy for those in the Tesla.
Yeah.
We have a number of really terrific questions from our audience. I want to make sure we give them enough time as well. One is actually quite existential, and I think you all have much to say about it. An anonymous attendee would like to know, how close is the Supreme Court to a legitimacy crisis? And they advert directly to these statements by Justices Barrett, Breyer, and Thomas that the court is not composed of partisan hacks. So what do you all think? Is this a legitimacy crisis for the court?
I think, look, I think there are people out there that are trying to create a legitimacy crisis and frankly trying to delegitimize the court.
Are those people on the court though?
On the court? No, I don't think that the people on the court are trying to do that. No, I think the people on the court are trying to defend themselves and say that we are legitimate and we are independent. And I think one of the things that's been heartening from the justices is the fact that it hasn't been just justices of one side or another. I think Justice Breyer, frankly, has been, he's been in the toughest spot maybe because I think the concerns and the effort to delegitimize have come predominantly from the left. And I think Justice Breyer basically stood up to that wing in the same way that Justice Ginsburg did before she passed away when she was asked about court packing. And I think she and now Breyer are being sort of courageous and taking the longer view. I do think that there is an attack on the court's legitimacy. I think there are a lot of concerns and frustration and anger going back to the appointments of Justice Gorsuch and Justice Barrett in particular, but also Justice Kavanaugh for different reasons procedurally. And I think that people are trying to feed off of that and trying to portray every ruling from the court as being, the product of partisanship. And, frankly, it's not just the left. I think that President Trump didn't really help things much by essentially treating the justices or talking about them as though he thought they should be loyal to him because he appointed them. And that's obviously not how they have seen themselves. So I do think that there is this sort of political dynamic out there. I think it's good that the justices are standing up for themselves, but I think that the best thing that they can do to maintain their legitimacy is kind of put their heads down and decide the cases as best they can based on the law. And I think that inevitably what will happen if they do that is that they're going to issue opinions that aren't going to please everyone on one side or everyone on the other side. It's going to be a little bit muddled. And I think that's one way to show the American public that you're not just a bunch of, as I think Justice Kagan has put it, or Justice Breyer, junior varsity politicians, but who would always vote for their own side, but rather you're going to get a bunch of cases that are 6-3 on ideological lines, but you're also going to get a bunch of interesting and important cross-ideological cases that are also important, like in the Obamacare case last year.
Joan, Troy, is this an existential crisis? Roman says no. And if it is, it's being fed up by both sides.
Well, I want to hear what Joan has to say. I'm a little skeptical that it doesn't seem to me actually that the volume of the court's justices' statements about the legitimacy of the court, that they're not political hacks. They say this all the time. It may be more pointed.
They usually don't all say it at the same time.
Well, but I think that's partly because they're back on the speaking circuit now. I mean, so some of this may be the kind of the compression that comes from COVID, where now they're actually out there speaking, saying this, and also that we're paying attention to it. To me, it seems like what they say all the time. It doesn't seem that different to me. And Breyer, this has been a long-standing view of Justice Breyer. It's how he views himself, not just how he views the court and the role of justices and judges more broadly. So I can't really detect any sense of true concern on the part of the justices. That's just my reaction to the recent flurry.
So Joan, you probably already have a sense of where I am with this. I think the fact that all three of them are out there saying this while we have a Supreme Court commission sort of gathering or documenting what's going on at the court and more vocal cries for court reform, I think that has infiltrated to some degree. Am I totally off base here that the court is not worried about its own legitimacy?
No, I think the court is always concerned about its standing with the public in this regard. It knows that it depends on public confidence. It, as Justice Breyer writes in his books, and the other justices have said at different points, they don't have an army, they don't have the power of the purse. What they have is their integrity and the confidence that they've built up over the years. And I think they've always depended on that. And I think you do sense a little bit more defensiveness right now about what they've done. And I think that, well, I know from talking to various justices that even though that court packing, court expansion idea is unlikely to go anywhere, given that Congress and President Biden don't want it, the politicians don't want it, and that term limits probably won't go anywhere right now because of the constitutional change it would require. Just having those over their heads kind of just makes them more aware of what threats to public confidence there are. So I don't think it's an issue that that they can just turn away from, or that they want to turn away from. I remember one of the first speeches that Chief Justice John Roberts gave soon after he came to the bench was, how should the public understand the court? And he tried to get people's attention for, this is not a political body. There's not much that people can do if they don't like our decisions, but he wants people to nonetheless abide by decisions. And that's a deep entrenched historical notion. And it comes from integrity and legitimacy that was built over time. And I don't think any of the nine want to backslide on that.
All right, that's a great place to leave it. The court, they try harder. Thank you for joining us for today's Latham and Watkins Forum. Thank you to Latham and Watkins for supporting NYU Law. Thank you to Michael Ori, Joe Rivera, and Ian Anderson and the production team. And many, many thanks to our fantastic panelists. It was a pleasure to be in conversation with all of you. And thanks to our audience for your engagement and participation.